broadly to Black people. So that was Rosewood. We also have the Japanese American reparations. That was, in fact, given right before the formation of NCOBRA. The president signed a bill that gave reparations in the form of, to me, it was minuscule to many of us. This is so it's like, it was given, but it was so de minimis. $20,000 for any living Japanese American who was interned, and if they died after the signing of the legislation, then their descendants got it. It also provided money for educational opportunities, art, those kinds of things, to talk about what happened to and depicted in art and other forms of what happened to the Japanese Americans. Thank you.
Here we see an example of the 1994 Florida legislature passed the bill that granted the reparations for the 1923 Rosewood massacre. And the amount of reparations that those who could prove that they owned property during the massacre received $150,000 in payments.
In 1923, the black town of Rosewood was a land of opportunity.
You've been drifting along, Mr. Man.
Seemed like forever.
Colored folks own all the land around here, all the businesses too. Man can make a new start around here, make something of himself.
Until the day one woman's false accusation,
Tell me the truth. Was it true that color done this to you?
unleashed a fury against their town.
If you find him, well, you know what to do.
There be some trouble around here, sir. To show use your help.
There ain't no way in the world one man got enough bullets for all them crackers.
And a search for the guilty became a hunt for the innocent.
These are real folks dying. Women and children ain't done nothing wrong to no soul.
Now, colored folk just can't be running all the time. There comes a time when you got to stand up and defend your rights.
So Rosewood was made into a film, which demonstrates the massacre that occurred in the 1923s. And Adjoa told you about the reparations that they received. Adjoa?
Okay. So NCOBRA developed in the late 1990s what's called 5 injury areas. NCOBRA developed it first through the Legal Strategies Commission that I chaired at that time and participated in with a number of members of NCBL, many of whom were also members of NCOBRA, with non-lawyers as well as lawyers. Some of the non-lawyers, Kalanje Olusegun, we have to lift up his name. He's an ancestor. Leonard Dunstan, lifting up his name, who was just recently became an ancestor. Rosalind Prudhomme, both Leonard and Rosalind Prudhomme were with the National Association of Black Social Workers. Mark Fancher was with the National Council of Black Lawyers. Shokwe Lumumba was a member. Masamel Mfomo, many of you know by the name of Mark Thompson, was a member, and there were others. It was a fairly large committee. We met once a month on Saturday, and out of that, the idea came to develop the 5 injury areas, because the question was, how do we define our injury? And we felt we needed to define it. And the 5 injury areas include criminal punishment, education, health, peoplehood, nationhood. I'll explain that just very briefly. It was the destruction of African people's culture and the imposition of the larger culture upon Black people of African descent in the colonies and then in the United States. Modern day example, voter suppression, modern day example, and then wealth and poverty, of course. That's another area. So those 5 were major areas that we felt when we looked at it, you couldn't probably look at any other remedy and of injury and not be able to fit it within one of those five. We felt they were categories broad enough to cover much of the injury, if not all, that occurred as a result of slavery and its legacies. Thank you.
So the question becomes, can money alone repair the harms? And Ms. Adjoa just went through the 5 injury areas as defined by in Cobra, criminal punishment, education, health, peoplehood and nationhood, and wealth and poverty. And when you look at those injury areas, you realize that like money alone is insufficient. Reparative justice requires that we are working on not just economic growth, but also the societal injustices and recognizing the structural harms that we endure as a people. So one of the things that sticks out to me when I think about like, is money sufficient for the harms that we suffer, is some of the things that just happened recently, like the death of the murder of Sonia Massey, and like the devaluing of the humanity of Black people that could never be repaired by money. Adjoa?
One of the things that I think we have to look at if we're looking at what forms reparations should take in a way, and that comes later, of course. But when we look at money and we look at the need to repair, we know that there's a need for fundamental structural change. You can give me a check uh, 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 for, let's say you decide, well, we'll give everybody a $50 check. And I'm just de minimis. I know I'm just giving this as an example, but that doesn't change the structural problems that existed and exist in the United States that allow for the continuing vestiges of slavery. It doesn't change the continuing passage of these repressive laws that are voter suppressive laws that keep Black people and other people of color, but they're targeted to us, out of the polls that restrict our access. It doesn't address the continuing differences. We'll talk a little bit later about the Supreme Court cases that limit and restrict really the attempt by schools of higher education to develop a more diverse body so that in their classrooms that address historical exclusion really of Black people. Money doesn't change that. So when we look at reparations, we must look at it. We're not saying that you don't look at whether or not there's a check or not, but for us, you have to look at what are the structural changes. How do we change the fact that there is data that supports that Black people, particularly Black men and white men, are treated differently in the criminal punishment system? We have some data for Black women and white women too, so don't get me wrong, but the larger data is Black men and white men. For the same crime, Black men get a significantly larger, harsher punishment. Money's not going to change that. So for true reparative justice, to really repair the injuries that we have suffered and continue to suffer because of slavery and its vestiges, we must design and push for structural changes.
Did you want to say anything about economic growth?
Yeah, I guess I was, when you put that up there, I thought, one of the things that it seems to me too is we have to look at as an individual check doesn't in and of itself help our overall economic growth. So what are the things, for example, and Nick will talk some about this later, when we look at the cases that the courts, the Supreme Court said, oh, no, Richmond, Virginia, you can't have a program that targets formerly excluded Black companies from getting subcontracts. So you can't have a program that targets them and says, okay, you have to be included in various components of the process of getting subcontracts. What the Supreme Court did is, and that's one of the bases of economic growth, right? Building our companies, building our communities. We were left out. We were not just left out. It wasn't like a negligent thing. We were consciously left out. We were consciously not allow business loans, not engage in getting contracts with larger, with governments, also with private industry. So you don't change that by just giving me a check. You have to change the structures. We have to struggle to figure out and work to figure out how do we address the limitations that now have been placed by the Supreme Court on actually reparations. We'll talk later about race-specific remedies.
Thank you. Nick?
So I guess to talk broadly then about those sort of changes or repairs, we have to talk about the various forms of reparations that are available to us. And the United Nations calls for 5 different forms. The first is satisfaction, which is inclusive of cessation of the violations, truth-seeking public apologies, judicial and administrative sanctions, and commemoration and memorialization. And so in the United States, we've seen some of this, but there hasn't ever been full repair. So as an example, in the United States, when it comes to Black folks, at least, we've seen the passage of various laws to cease violations or further discrimination. We have, for example, President Clinton apologizing for slavery. We have various different monuments and things of that nature erected to the folks who were victims of lynching in southern states. So we have these individual one-off remedies that the United States has done historically, but never, sort of full repair. So we have some examples of satisfaction. The next one is compensation, which most people spend a lot of time and energy on. And as a lawyer, I will say that our Western court system, our Western system of justice, this is what the focus is. Money is always meant to repair you for your harms, whether it's a catastrophic injury, whether it's the loss of your employment, whether it was discrimination based on your race or sex or gender. Money is always, meant to make you feel better in our justice system. And that goes hand in hand with the next one, which is sort of restitution, right? Paying you back for what you lost, or bringing you back to what you would have been but for the injury is restitution. So those things sort of go hand in hand. The last two are equally as important, which one is the guarantee of non-repetition, which is, as Adjoa talked about, institutional reform, changing the actual institutions in which brought about the issues in the first place, as well as strengthening judicial independence, and really the promotion of our international human rights standards in public service and law enforcement. Locally or here in the United States, those standards don't necessarily apply to our local law enforcement. And so in order to guarantee non-repetition for these harms that have already been discussed, we actually need to change the structures of the institutions that we live in. And the last is rehabilitation. We know that, again, our justice system, at least when it talks about criminal reform, there's a really bad echo. I think someone needs to mute. Part of that is to try and rehabilitate folks, but we know that is not always the case. But that rehabilitation helps to provide comprehensive reparations when you actually have the medical and psychological care as well as legal and social services. I recently watched a movie about the assassination of Lincoln, or I'm sorry, it was a series about the assassination of Lincoln. And it talked about the efforts after the passage of the 13th Amendment to try and offer some rehabilitation for those recently emancipated. As we know very well that effort was stymied with the assassination of Lincoln, but at least in that time, there was an idea, or there were those who were already thinking about the necessity of bringing this type of repair forward on behalf of those who were recently emancipated.
Thank you. So there are some comments in the chat, and I'll read them. Reparations. Kathy reminds us that reparations for Japanese Americans was given only to those who were alive when the bill was signed on August 10th, 1988. Heirs did not receive reparations for those who passed after that date. And the question was, should reparations only be given to those who are alive? And how does that relate to like what we're talking about with respect to those who are enslaved, which leads directly into our next point, which is eligibility.
Well, can
So,
I say something, Theresa, please?
absolutely.
I want to make a correction. The bill did allow for if I was alive, and then I'm dead, alive at the time, and I'm a Japanese American who was interned, and I died after the bill was signed, the heirs did get the money, but it was not a descendant bill. In other words, it was a bill only, it's like, I don't know, technically, Nick may be able to know the name, but it vested. Once it's vested, if that's the correct word, I think it is, it's vested in I now own it. So then it went to my heirs. But before it was vested, before the bill was signed, it did not go to heirs. So I just want to make that clear.
Thank you, Adjoa. So there are a few types of conversations that are happening in the community about who is possibly eligible. And we're going to listen to some conversations around this before I explain what the 3 criteria are.
The first criteria is a lineage standard. An individual would have to demonstrate that they have at least one ancestor who was enslaved in the United States. The anchor for this program is the failure to provide the formerly enslaved with the 40 acres that they merited at the end of the period of enslavement. And this failure is what has had long repercussions for living Black American descendants of U.S. slavery.
So the descendants of enslaved Africans is the narrowest eligibility category, that only descendants of enslaved Africans should be eligible for reparations. This category is based on evidence that persons who descended from evidence presented by persons who descended from enslaved Africans. And William Doherty, who you just heard speak, has proposed measures for identifying through for the lineage argument by things that are consistent with the use of DNA, things that have to do with like when you identify as a person of color on your census. Some of the concerns about this specific area or this specific eligibility criteria has to do with its like being as elitist as what was the brown paper bag test had been for people of color. It is very exclusionary, and it relies on people being able to prove their lineage, which could be problematic and will likely be problematic given the nature of what was happening to enslaved individuals and the fact that our families and communities were separated and there was nothing documented to indicate who we were and who we were related to.
The second idea of eligibility, which I subscribe to, is defined in broader terms, encompassing all American Africans who have been adversely affected by systematic racism and discrimination, regardless of their specific ancestry, nationality, or country of origin. These proponents of harm-based reparations, which I think should be the only eligible criteria, argue that reparations should be based on the ongoing effects of past injustices, regardless of nationality, regardless of an individual group's direct historical connection to the harm. They argue that certain communities continue to suffer from the legacy of slavery, colonialism, and other forms of systematic oppression.
So he is talking about one of the largest eligibility criteria. We're going to just listen to Lisa Holder, who has a little bit more to say about that.
Social science has to really be the underpinning for any policy, especially any policy that is going to undergo judicial scrutiny at some point. And so social science needs to be the underpinning for reparations. It needs to be the underpinning for eligibility. The social science that we are able to gather over the last 15 years, and the social science that we certainly gathered on the California Reparations Task Force, shows definitively that continuing racism, the vestiges of slavery, institutionalized racism, stems from anti-Black discrimination, stems from anti-Black animus, and stems from a narrative of anti-Blackness that goes back to 1619. And it's very important to understand that that narrative of anti-Blackness was actually the driver of slavery, not the other way around. Right? And so when we are thinking about repairing the harm of 400 years of discrimination, we have to go to its root cause, which is anti-Blackness. And if you're going to use anti-Blackness, if you're going to garner that social science and you're going to use that narrative, then you have to have an expansive reparations that deals with the harm of having Black skin in America.
So this eligibility category that the two of them are discussing acknowledges that it identifies people who are Black are injured by slavery's legacies, regardless of their ability to trace their genetic lineage to slavery in America, or to prove that they are suffering a specific harm in court. So this category assumes that all Black people of African descent have been harmed, even if it has not been in a demonstrable way necessarily. This can look like all variations of micro and macroaggressions. It could look at the threat that we suffer from police as a result of our skin color. A challenge to this is that the category typically requires some consistent identification as Black, like who identifies as Black because they get this reparations when they hadn't done so previously, and making sure that the benefits go to people who identify as Black and not necessarily those who are newly identifying as Black, or those who, like, because of the breadth of our collective tones and variations as Black people, the criticism is like everyone doesn't necessarily suffer those injustices because of the different ways that we look. The third one that neither talked about is like relating the eligibility to a specific injury. It would be something like Rosewood, it would be something like Tulsa, or something like people who were specifically incarcerated, and they were incarcerated for a longer period of time than white people were incarcerated for the same crimes. That would be a specific injury, and those people would be eligible for reparations. Those are the varying
The first criteria
that you should know about.
One of the things I think when we look at the legal framework and we just look at eligibility we just finished talking about, I want to put just briefly, and I have to say to myself just briefly so that I don't talk too long, put in context, what is the anti-Blackness argument? If we look at the foundation of this country and we look at the creation in the 15th and 16th century before this country was founded, of what's called the racial hierarchy, that was, and it was a white male creation. It wasn't neutral. It was a white male creation that we have to look at, that says white people aren't on the top. Excuse me, 1 minute. I didn't mute my phone.
You're on mute, Adjoa.
Thank you. That phone never rings. But if we look at the creation of the racial hierarchy by German in the 15th, 16th century, 15th century, I believe, they created this hierarchy that started with whites at the top, Caucasians, and went down by shades of color, right? And then they began over a period of time to ascribe values and behaviors and to those categories. And I wrote a paper on this, so, I'm not going to go through the whole thing because it'll be much longer we have time for. But what you look at is it's man created, white male created. And then it was used to justify by a Southern physician, justify the enslavement of African people. And then we go on and how it's been built and built and built, even to the point, as Jesse Jackson made many years ago, that we have bought it. That if you're walking down the street and you see a group of Black men, young men, standing, you cross the street. If you see a group of white men standing, this is a generalization, and white men standing, you keep going, white young men standing. So this is this is a created thing. It is not real. So if you look at the legal framework, you have to start with the foundation of that framework. We can't just take the United States Supreme Court's decision out of the context of how they were raised in a society that gave elitist, hierarchical, superiority values to white people. So we use that and we look at that and how it's embedded in our society, so that the legal framework that Nick is going to discuss more in detail. But if we look at it from fair admissions, the last case that people were all up in arms about, which, we should be up in arms some about, I'm not saying we shouldn't, in 2023. But that whole historical piece of law that started early on, we had a slight break with Brown v. Board, and then we started going back. Bakke kind of narrowed it, and then Nick will go on and on and on. But it is based in the view that's more than a view. It's, as I said, that it's in the bones of this country that in fact whites are superior and Blacks are inferior. The lie. Nick.
Okay, I'm and I know that there's a lot of discussion going on in the chat about it's much more of a hindsight discussion, but I'm only going to address with what we have in front of us in terms of where we are today. And so the 14th Amendment was originally passed not only to give us naturalization, the recently emancipated naturalization, because prior to the passage of the 14th Amendment, the Africans in America were not citizens, they were property. And in fact, in terms of counted for the census, they were only 3/5 of a person. So until the 14th Amendment, those individuals were not considered citizens. And so after the 14th Amendment, we had naturalization, but also it was originally a shield for state action against discrimination of those who were recently emancipated. And so, however, as Supreme Court precedent has gone on to interpret the 14th Amendment and the various federal laws after it, it is no longer really a shield. I mean, the 14th Amendment was given to desegregate the schools and to do other things to sort of protect us against state discrimination. But along the line, it has now become sort of a sword to stop, or a shield to stop from any sort of restoration or repair. So the first seminal case that I know that I used in the city of Evanston was the city of Richmond versus J.A. Croson, which the city of Richmond tried to set up a quota program to allocate city contracts to 30% of all city contracts to minority and women-owned businesses. And the Supreme Court held that this program was unconstitutional, that only Congress can identify and redress private discrimination, and that state and local governments can only remedy harms caused by their own policies and practices. And that was key because the city of Richmond didn't have evidence that it discriminated against women and minorities in the area, specifically the area of city contracting. And so in an effort to try and help some economic redress for minority and women-owned businesses, the city had put in this program in order to give some of its contracts, understanding that private contracts may not fall in line, but the Supreme Court said that this was unconstitutional. The other case was Adirondack Contractors versus Pena, which was a case brought against the Department of Transportation. The U.S. Department of Transportation had provided highway contracts to disadvantaged businesses. And in doing so, the Supreme Court said that even the federal government had to meet the standard of strict scrutiny. So any policy meant to harm or meant to repair harm based on race had to be narrowly tailored to meet the specific harm that was brought. And so again, we see the Department of Transportation's program did not have sufficient evidence of harm. And so these two cases, along with the next two cases, sorry, we went one slide too far, sort of help us understand not necessarily how we might be able to provide reparations or restorative repair from a legal standpoint, but they sort of shape and frame what we need in order to be successful. We need evidence, specific evidence of the harm that was caused. And then we see that here in Jacobs versus Barr, which was the only challenge that I've been able to find of the Civil Liberties Act of 1988. The court, the DC Circuit, upheld the statute based on the extensive record in front of Congress regarding the internment of Japanese Americans. This particular case was brought by a German American who was interned with his father. The difference that Congress had found is that essentially Japanese Americans were interned solely based on their nationality and the fact that they were Japanese, whereas German Americans or German immigrants actually got due process. They actually had individualized hearings before they were interned. And so in upholding the law, they again, the courts relied on the sufficient evidence found in the record to justify reparations payments. And then we see Harvard versus Fair Admissions, the case that Adjoa just recently brought up, where the Supreme Court recently overturned race-conscious admissions policies as unconstitutional. And, you know, I tell people this as often as I can say it. The reason why Harvard and North Carolina and any other university that wishes to base admissions or use race as a factor on admissions is unable to do so now is because their refusal to admit and address the fact that they were discriminated in the past. So the other cases that we've sort of talked about address the need and the necessity for a record. And so in Evanston, one of the things that we did was admit and take accountability and responsibility and culpability for the discriminatory policies and practices implemented by the city council in the past. And so the first step in trying to offer repair is at least some sort of acceptance of accountability of the harm, right? And so what we see here in the United States is no one really willing to accept accountability and responsibility, but they want to make it right. And the Supreme Court has told us, well, you can't really make right something that you haven't done wrong. So first we have to admit and accept accountability of what has happened, whether that be stripping the right of someone to declare their citizenship as being discussed in the chat, whether it's lynching, whether it's over-policing, whether it's miseducation, refusing the right to vote, any of the atrocities that have been brought upon the descendants of those who were previously enslaved, we could take any flashpoint in history and start from there because there's been so many. You take that and have an admission of guilt or an accountability of harm, we can start from there and actually be able to implement any sort of program based on race, provided we have sufficient evidence. And so that is sort of the legal framework that we're working with here, is we understand that we have courts that are not necessarily favorable to offering repair unless it's to a specific individual who, as we talked about, someone who was specifically wrongfully imprisoned or someone who was specifically discriminated against. We have courts that really address those individualized harms. But if we want broad-based policy or any sort of remedy to impact on a broader scale, we need to be able to formulate that evidence of harm across the board, as well as couple that with an admission by the bad actors in order to do so.
Thank you. Adjoa.
So what are race-based remedies? We have this slide up. I think if we just start with the fact that what race-based remedies are would be remedies that are designed for the correction or the healing, or I don't want to use the word remedies again, to the injuries, for the injuries caused because of the group's identity. So on the race-based group's identity. Now, so if we look at a race-based remedy, if we look at Evanston, in many ways, the formulation of the ancestor category, those were race-based remedies. And so what the court is saying, as Nick just described, is that those are severely restricted. But the injury was to us based on, in quotes, race. I argue it's really not race, they're based on phenotype, but that's a discussion for another day. So when we look at race-based remedies, that's what we're talking about when the various groups, many of them represented here, others are trying to develop remedies for the injuries caused to Black people based on their identification as Black people.
Okay. So we are going to ask you to participate in this section of our presentation by taking a couple of polls. I actually can, Kiara, put the polls in the actually, no, I can't. So yes, please do put the polls in the chat for me.
I'm adding them right now.
Thank you. So the first poll, so the point of this is for you to understand and really work through like what narrowly tailored looks like. So Nick and Adjoa talked about the fact that race-based remedies start with an admission of wrongdoing and accountability of for the harm, and then that you need sufficient evidence. But you also need to have whatever you create to redress the results of the action be narrowly tailored to like the specific wrongdoing. So let's see what that would look like in layman's terms. So in the first one that's in the chat says that there is a
It's on the screen.
interaction between Jessica and Tim. And Tim has a bag of 10 Granny Smith apples. Jessica takes all 10. She eats 3 and then she throws them away. So what's the effect of Jessica's actions? The effect of Jessica's actions is Tim now has 0 apples and is hungry and sad because he has no apples. So what do we think that Jessica needs to do to provide reparations for Tim for her actions? Should she, number 1, so hard to see, sorry. Buy Tim give Tim 7 Granny Smith apples, 7 apples that she tossed out. Should she buy Tim 3 Granny Smith apples? Should she buy Tim 3 apples of another kind? Or should she buy Tim a new bag of 10 Granny Smith apples?
Are they going to be on the screen so they're not on the screen that you just read?
No, they're not going to be on the screen. They're in the chat. So you guys can choose 1, 2, 3, or 4. Okay. Thank you, Carol. So buy a new bag is what I'm getting. And yes, in order to narrowly tailor the remedy to address the issue, Jessica has to buy Tim a new bag of 10 fresh Granny Smith apples. She can't buy the Macintosh apples because the remedy has to match the harm. So we're going to do another example that's closer to what might happen in real life for us. Local and state governments took land owned by Blacks without paying fair market value. So the Black people in that locality, this is the effect of their action. The Black people in that locality lost their homes and their neighborhoods were forced to relocate without any economic benefit resulting in increased poverty to those individuals. And I'll put these options on the screen so that we can discuss them. So here are the 4 options. Option number 1, Black people whose land was taken should be given their land back. Number 2, Black people whose land was taken should be given the fair market value of the land that was taken and all costs related to their relocation. Number 3, the local and state governments should invest in upgrading the infrastructure in the newly created communities where Black people were relocated. And number 4, all Black people in the town should receive a homeowner's credit equal to 20% of the fair market value of their homes.
I just wanted to jump in and talk about the interplay here of this particular example of both the 5th Amendment and the 14th Amendment of the Constitution here. Here you have an improper taking in violation of the 5th Amendment on the basis of race in violation of the 14th. And so the reason why that's important is our relief, our remedy, and from a 14th Amendment context needs to be narrowly tailored. But in the 5th Amendment context, it does not. And so that's why I just wanted to point out the interesting interplay here with respect to the takings, although there's, it doesn't necessarily need to be narrowly tailored, but it usually has a simple remedy. And then the 14th Amendment, which does need to be narrowly tailored because of the factor of race.
Thank you, Nick. So I see some answers coming in, 1s and 2s. Somebody has all 4. I mean, when Adjoa and I took a look at this example or created this example, we talked about like the fact that there is probably more than one thing that could happen as a remedy, as a redress by the government in this instance, right? So there are multiple things that could make somebody whole or more whole. But there's probably one thing that I would say is less likely to have the remedy because it's to be the appropriate remedy because it's too broad. And that's number 4. But I see Nick came off of mute, so he wants to
Yeah,
join the conversation.
I'm just gonna point out that 3 and 4, and the reason why I bring this up, well, 3 and 4 is definitely too broad. And I think 3 is also problematic. And we talked about this, and this may bring Robin all the way back to 2020 and 2021. But number 3 almost reinforces the segregative problem that was caused by taking of the land, right? So like, okay, we're going to invest in the infrastructure of the area that we segregated you in order to make that better, but we're not going to allow you to, still become integrated fully into the community. And so while state and local governments most likely would do 3, and we've seen investments in that. I was able to buy my home with government money in a Black neighborhood because they were trying to invest in those neighborhoods. But it just furthers the segregation that was caused by the original harm in the first place. And so the real remedy, I think, in this example has to be probably 1 or 2 in order for it to really bring about the point, which is repair and restoration.
Thank you. So what we're saying around 3 is that like it doesn't match the harm, right? And 4 is too broad. And that's why 1 and 2 are probably the best solutions. Adjoa, I heard you wanted to come off mute.
Yeah, I did come off mute. I guess one thought though, to Nick's point about integration is that really the goal of this problem? In other words, Black people's land was taken, the government moved them, or they had to move, whether the government moved or not, and they bought land someplace else, or they settled somewhere else. Was the goal integration, or was the goal to be able to have your land? And that's how I would look at it. So that's why I would support either 1 or 2. I agree 3 is too broad, but I'm not sure I've got stuck on the issue of integration. I'm not sure that would be.
For sure. And I to your point, likely when the state and local government took the land, they were trying to not have integration. They were trying to segregate. And often what you see by state and local governments to try and repair that harm, they don't want to address the idea that land was taken, right? Or that people were relocated. But what they'll do then is take that land, for its public benefit, and build pools and tennis courts and parks and say, hey, it's for everybody. And so, there was no harm, no foul. They don't really want to accept the consequence of what the original purpose, to your point, of taking the land.
Which goes back to like admitting the wrongdoing, being accountable for the harm, and then, having the evidence and providing something that's narrowly tailored. So these are the kinds of things that you guys will be thinking about as you work on the work that you're doing.
One of the things, so I think if I could, is let's not use narrowly tailored to say the breadth. In other words, the narrowly tailored means narrowly tailored to satisfy the remedy. So you don't get 2 pieces of land. You get 1 piece of land if that was taken. And so I'm saying that because non-lawyers look at that term and may view it as narrowly tailored as being restrictive. It is saying that you, to me at least, well, to me and others who are lawyers, to me it's saying that you can't give me more than what was taken or what was my due, which I think is the point about 3 and 4 being too broad. So I just wanted to jump in because we're talking with people who aren't lawyers, that legal language doesn't mean you don't meet the injury or the harm.
So, we're gonna, unless anybody has any specific questions on this before we move on. I know that there are questions in the chat, and some of them I will go back to at the end. But if there's questions here, I just want to make sure people have a chance to ask. Is option one even possible if we're talking about eminent domain? Then there is now an interstate shopping mall, new condos, or is the government going to force people who now live on the land, I guess, to leave?
That's sort of an excellent question, and it's one of the questions that's come up in Detroit with the building of highway. I can't remember the highway number right now. And I mean, even in Chicago, 1994 was built through the South Side after displacement of folks who had been living here. I think, you're talking about eminent domain, and one of the facets of eminent domain, and what it's supposed to be, is payment of fair market value of the property. And so we're talking about, at least in this particular example, in this hypothetical, that the government took the land and didn't pay fair market value. And so the repair is, no, we can't move those people back. We can't give them that land back. But then you have to get creative with your particular solution as a result. And the reason why I say creative, because the fair market value of the property then versus now you're talking about inflation. And then also now it's not even livable anymore. It's a highway, right? So you have to be, creative in terms of your remedy in providing that restoration. And I'm not an actuary. I'm not a property assessor. I can't tell you what that math looks like, but I do know that, the law requires fair market value, and you have to be probably creative. We can't move people back. We can't give them the land back. It's now something else. If it has been given to a developer for condos or, a shopping mall or what have you, then that does open up some particular possibilities. Because what happened was the government took the land and then resold it for private use, under the guise of public benefit, because obviously people can shop, and, now you have housing available on the condos. But it does, there is some broader options available than if it were for, say, an interstate.
One of the things too is, let's not forget, was it Bruce Beach in California?
Yes.
Where the land was taken and then the land was given back, and then they sold it back to the city, but that's a whole nother discussion. And so there are times when the land can be given back, but for the most part, as you're talking about, Nick, and Jamoki's question raises, for the most part, that actual land cannot be given back. There's
Right.
another thing that, I beg your pardon?
No, I was just going to say, as part of the land not being able to be given back, it's mostly because of a lot of our state constitutions do not allow the state or any of its local governments to give public property specifically for a private benefit. So even if the state took the land, like Bruce's Beach, they couldn't give it back to the private actors. They had to actually pass some sort of legislation that allowed the city to sell it back to the family, and the family, in order to get their fair market value, sold it back to the city. I think there was like a minor, it was like $1 or something like that the family brought it back from the public in order to get it, because this California Constitution wouldn't allow them to give it back or something silly like that.
But I guess what I'm saying is, without all the detail, is that is an instance where the land was not changed, so to speak, so that it could not be given back. And I thank you for all that detail. The point, though, I think that I want to also make is, many times in the law, and I don't know if it applies to eminent domain, and maybe Nick does, is that if you take something from me, and then you sell it to a buyer that has no knowledge that it was taken, that it was not properly yours, so to speak, then you can't get the land, you can't get the item back. And I think it applies to land as well, because it's a buyer in good faith or something like that. So that there are lots of different hoops or restrictions or laws that apply in all of this, so that the cleanest way unless you can do a Bruce Beach thing, like Nick said, maybe it was complicated with the legislature, but a Bruce Beach thing is number 2. Give me back my land. I mean, the value of my land, the fair market value. And I would argue also the cost that I had to spend in relocation. Okay.
There's one other good point in the chat about this section, which was Joan, who talked about people not necessarily wanting to go back to the place where they left because they were harmed by the trauma that resulted from them having to leave in the first place. So thank you for that point, Joan. All right, Nick?
So alternatively, we look at a legislative remedy because we know the courts are hostile to the idea of providing broad repair. And so, in developing this legislative framework, something that my consulting firm, in conjunction with the lessons learned at Evanston, we've identified a way to sort of try and resolve this. If it's going to be the government actors that are providing reparations, we have to do it through legislation. So we develop political will, meaning that you have to sell the idea to constituents. I was on a call last night with Kansas City, and it doesn't appear as if, even though there is a commission in place, it does not appear they have full political will in the city of Kansas City, Missouri, in order to really impact or make impactful reparations and restorative repair. This idea of selling the idea of constituents has to include your grassroots groups, as well as developing a communications and education plan. One of the things that, in Evanston we had to do was to get out into the community, and we had, which is the very next point, identify an effective legislator. We had Robin Ruth Simmons as the face of the work, and she was engaged in the community and trying to provide education to individuals as to what reparations really is and the purpose of what we were trying to do, in addition to the necessity of having public meetings so that the public could actually hear that, hey, the city can only repair harms effectuated by the city. And so having an effective legislator allows for the effective communication, not only with the community, but with their colleagues, because you need to secure votes. We are talking about politics here. So you need to be able to secure votes in support of any legislation that comes out of it. The next thing is to essentially do the research, commission a study, and write and publish a harms report. Your harm report is going to serve as the foundation of any repair and restoration. It specifically identifies the harms, the period of harm, and your harmed parties. So the conversation we had earlier about eligibility, you do this research, you're going to be able to find out who's eligible real quick, because you have details on not only what the harms were, but who was harmed and for how long they were harmed. And it should be included as part of any legislative repair. It should be referenced in any legislation or part of its recitals or anything of that nature. Your harms report should be incorporated by reference into any legislation. Next, we start talking about developing the reparations program. It's going to be based on your harm report. It's going to be your compelling governmental interest of repair and restoration for past racial injustice. There's an argument that the Supreme Court has said repair and restoration for racial injustice is not a compelling governmental interest. I disagree. I think, it's not a compelling governmental interest to repair and restore broad racial injustice, but it is a compelling governmental interest to repair your own racial injustice as a government body, as a government entity. And it must be narrowly tailored to address the specific harms to individuals. And so your program is developed, again, based on the harms report. We know who was harmed. We know how long they were harmed. We know what the harms were. So that's how you sort of develop in your program and exactly what you're going to do to repair the harm. And you have to identify a funding source. Evanston was very fortunate that it had a new funding source coming online in 2020 that had not been tapped by the city council. It was a voluntary tax to be paid by those who bought adult use cannabis in the dispensary. So it wasn't something that was generally taxed to everybody. It could be assessed to visitors of the city. It could be assessed to residents of the city, tourists. You know, it wasn't. It was very much a voluntary tax. You can have a mix of public and private funds as well. On the Osiris Professional Services website, as well as I believe First Repair, we have our legislative toolkit published, which now includes a funding matrix for legislative bodies to take a look at for examples of various different types of public funds that can be used for reparations, and the benefits and the downside of such using those public funds. And lastly, somewhat obviously, introduce the legislation. You actually have to pass either the resolution, ordinance, or statute. Inside that legislation, you need to have acknowledgement and apology. Also on my website is published the Florida claim bill that was used to provide reparations to those folks who were impacted by Rosewood. You will see in that legislation there's acknowledgement of what the state failed to do in order to protect those individuals from harm. Your legislation should also ban or otherwise outlaw the harmful acts that were outlined in your harm report. I would highly recommend a creation of an administrative agency or a body to administer that. I'm understanding that not every jurisdiction has the resources to be able to have another bureaucratic agency, but you look at, in the past, we had the Bureau, the Freedmen's Bureau was an example. The Office of Redress, created by the Civil Liberties Act of 1988, is still in practice and available. And then, obviously, as I mentioned before, incorporate by reference the harm report and sort of outline eligibility criteria and specifics on awards. So, in addition to your harm report, and I know we've already passed that slide, but you know, your research should also include testimonial evidence and hearings from people to actually tell their stories. And one of the other key pieces to that is we shouldn't necessarily take people's stories for free. People should be compensated for their time and actually for coming to tell their story, in addition to whatever repair that is given to as a result of the legislation that we are advocating for, since the courts are so hostile. And that is our legislative framework that we've developed to this point.
Okay.
It's the roaring 20s. The country is flourishing. Some African-American communities are prospering, like the residents of Greenwood in Tulsa, Oklahoma. Jones captures the bustling life of Greenwood, which could be any American small town. But Tulsa's whites don't like what they see. In May 1921, after a black man is accused of assaulting a white woman, a white mob rampages through the city. For a night and a day, they loot and burn Greenwood. A Fox News crew captures the only surviving footage. It is the bloodiest racial massacre in American history, leaving nearly 300 dead.
A visit to Mother Ranch. With the recent passing of Hughes Van Ellis, she's one of the last 2 Tulsa Race Massacre survivors left. After years of seeking reparations for that trauma, an Oklahoma judge dismissed the survivors' lawsuit in July, but an appeal has since been made.
109 years old. Got a birthday wish?
I would like to see all of my people here trying to make this situation better, bring some of those things to life so people will know that this really is true. There's room for a lot more improvement.
She needs to see justice in this lifetime.
So does Mother Fletcher. That's what they need to see in this lifetime while they're still alive.
It's the Roaring
Sorry. June 2024, there was a dismissal of the Tulsa case by the Oklahoma Supreme Court. It proclaimed that judicial reparations are impossible and relief can only come from local and state legislatures.
It's the Roaring 20s. The country is flourishing. It's the Roaring
Theresa.
Sorry.
Thank you.
The court, there we go. The court holds that Oklahoma courts are the wrong forum to seek relief, even though the plaintiffs claims that the blight of Greenwood District was caused by the city of Tulsa's actions during and after the 1921 race massacre falls squarely within Oklahoma's nuisance statute.
In ending, one of the things that I wanted to raise up, and this point here, this case is dear to my heart because I was, along with my colleague and comrade Charles Ogletree and others, Eric Miller, who was still active and was involved in this last case. We did the first case on Tulsa that was dismissed. And for me, we see here what I was talking about earlier, which is the foundational premise of many of these courts is based in white supremacy and the myth of white superiority. The court said in the first case that was dismissed in 2004, I believe 2003, 2004, that in fact the claim was initially that the statute of limitations had run. That was the motion to dismiss. We were able to show, and the court agreed, that at the time the statute began to run, that the plaintiffs could not have successfully litigated the case at all because the courts were full of KKK members and others. That information was hid from them. The court then said, yes, we agree with your argument. Legally, it's called equitable tolling. That means that we will stop the running of the statute of limitations until such time as the plaintiffs should have known that they had a right. What the court did was we were pushing for it to be 2000 or early 2000. The court said, well, this book came out that nobody really had heard about until recently when the commission that was formed in Tulsa to look into the massacre unearthed it in late 90s, early 2000s. But it was written in 1987. And so the court said this book should have alerted the plaintiffs that they had a right to sue. That is to me another example of how, you win one moment, but you really don't win because they find a way, the courts find a way that want to, and most of the courts do, to avoid giving the full remedy. In 2024, you heard the language talked about that was dismissed. That was the first dismissal of last year. It was dismissed by a lower court. It was appealed to the Supreme Court and for the June 2024 dismissal that you saw on the screen and that Theresa read. I guess for me in ending this segment, and I think Theresa's gonna come back and close us out.
Yeah, you have to call them.
Shamila, if you could mute. Thank you.
I think that it goes back to why are we in this, I call it a fight. And the courts to me, as Nick has explained, as I have explained some, but Nick more specifically, it's a road that is hazardous for us because there's always going to be rules that they prop up that kind of mean that we have to figure out another loop. But for me, and I'm gonna leave you with this somewhat non-legal perspective. To me, we have a responsibility to decide, do we keep fighting? And do we use the small entryway that we now have, that the court has not closed off, as we develop remedies in the communities? And in this sense, as Nick points out, we do the legislative piece. You're not confronted with the court immediately. You're only confronted with the court, as is happening now in Evanston, when somebody decides to challenge what's being done. But I would hope that those of you here representing, some of you representing commissions, local groups, some of you just perhaps representing yourself, will take what we have shared, and honestly shared. This is, and we all know it's no easy road. It wasn't an easy road for our ancestors. Many of the ancestors that that were enslaved, that were victimized by Jim Crow. It was no easy road. For me, the question is, do we keep fighting? Do we keep working together to see how we penetrate this wall and maintain it and support each other as we do it, and say, you know, the struggle continues. Victory is certain. Thank you.
Thank you. It is. Thank you to First Repair for the invitation to speak. And I also want to mention the interns who contributed to the presentation: Samuel Rhymes, Dominic Cravens, and April Hurley. So I'm going to stop sharing so we can get to your questions.
How do you want people?
I just wanted to address sorry, there was a conversation I was sort of having in the chat about the use of the Fair Housing Act. And I think one of the things that we would need to ensure is that the Fair Housing Act allows for a private right of cause of action. I believe that it does, but I know that that's come up in terms of the Voting Rights Act, actually, right? So that's been one of the things that's been used against us for the Voting Rights Act, to say it doesn't provide a private right of action, that only the Department of Justice can actually sue on behalf of under that statute. And I know that there have been plenty of cases brought by the Department of Justice, sort of on behalf of private individuals, but mainly on behalf of the government to enforce the Fair Housing Act. But I am not 100% sure that it can be used by a private individual in order to seek remedies under the Fair Housing Act. So I did want to address that to the broader group on that point.
If you have questions, please put your questions in the chat, and I'm gonna start from the beginning and read through the questions so that your experts, Adjoa and Nick, can answer for you. So the first question is, how can we use Project 2025 to assist us in proving how laws have disenfranchised the Black community? If we can. Anyone want to take that?
Well, there's a whole movement around Project 2025. I was on a program sponsored by the Proctor Institute. I'm not remembering the full name, but it's the Proctor Institute out of Chicago. And I'm not an expert in it at all. I know there are many groups that have developed and are working on that. So I would just, refer you to those groups, to look those groups up and see what their strategies are, because I don't want to mislead anybody.
I would sort of chime in only to say that it's really difficult. You can easily show the effect and the impact of some of these policies and practices, but to try and show that the purpose of it is actually really, really difficult. And so, at least in terms of its negative impact to like for the purpose of disenfranchising Black folks, as an example, I think it's much easier to use Project 2025 and any other policy plans like it to show that it really is meant to prop up and further establish white patriarchal supremacy than it is to show that it's meant to disenfranchise us. I think that the result results impact, the effect is going to be disenfranchisement of Black people. But really, if you look at Project 2025, it's really meant to sort of take us more out of a democratic republic situation and more into an authoritative not even oligarchical. It's more so like almost like a king queen situation, where you have power vested, a lot of power vested in the executive branch, which makes it more like a king. And with the Supreme Court's ruling about a lack of accountability for acts taken as president in office, you basically now have a king type of figure as opposed to a president that's accountable to the people. So that's I think it's easier to show that Project 2025 is meant for that purpose as opposed to showing ultimately it will have a negative impact. But I think unfortunately what we have to see in order to prove it is the impacts have to happen, right? We actually have to have those negative impacts in order to be able to make that proof.
So there was a question about citizenship that I think Nick addressed in the chat. There's one about eligibility. Is there a hybrid approach regarding eligibility?
I'm not sure. I guess one hybrid approach, which in Cobra had, in fact, I don't know if Cam is still here, but Cam helped me formulate eligibility in an article I was writing for Howard Law Review, and that included what I would call hybrid, which was including those who were descended from enslaved Africans and those who were not. And I think we can look at, for example, some of the discussion in the California task force before they ended, which is that you could argue that reparations are not only due for descendants of enslaved Africans, but also for descendants of free Africans that were free, so-called free. I put so-called because we know they were restricted too during slavery. So those could be a hybrid discussion of hybrid in that way. I think I know that NCBL and NCOBRA embrace the broader definition for eligibility that would not exclude descendants of enslaved Africans, but would be a broader grouping than just descendants of enslaved Africans.
And I would add that although I know that our focus is meant for us here, that we probably need to take a bit of a global view with respect to this. And I say that only after visiting the Permanent Forum on People of African Descent, and how this fight is not unique to the United States. We have a lot of folks in this hemisphere that are in this hemisphere because they were brought here by force. And so not only are reparations due to the descendants of slaves in North America, but Central America, South America as well. So I would argue that the eligibility criteria goes well beyond our borders, at least for those of us that are here. I also understand, I've heard the argument in terms of lineage, which arguably takes it outside of race, but does sort of talk about national origin. We are at this generation, so many of us so intermixed, right? So that descendancy not only includes someone who was likely enslaved, but also a descendant of a slaveholder. Because we know that folks were property, and so rape it wasn't even considered rape, you know. I know that I myself can trace my lineage to, on my mother's side, to a slaveholder. So, you know, we have to take that into consideration in terms of context as eligibility as well. So to the point about a hybrid model, I think we already are looking at it. When you talk about at least one, you can trace some ancestry. But I also think that we need to look at it in the bigger picture as well.
Okay,
One
so the
thing,
fair.
Theresa, I could, before we, because I don't want to
Mhm.
lose this, on the 2025, I'm sorry, I'm going back, 2025, it's Ivan Carruthers with the Samuel DeWitt Proctor Institute. They had a series on 2025. And I think one thing to add is I do think that 2025, when I read, and I have not read it in more than a week, so I may be remembering it a little off, but when they discussed it, it does include things like dismantling public education or having, so that even though, as Nick points out, it's a broader setting up more of a oligarchical or government, it also does dismantle many things that we depend on in our communities. So I just wanted to raise that as well. And I also want to raise that I did look up, because I was confused on the year. Rosewood was passed, the legislation was passed in 1994.
So we addressed the fair housing, and nationalization was addressed in the chat. Next question is, can we set up or have some mock trials to debate reparations, which would allow our youth to get a better handle on the devil we are working to get reparations from? Does anybody know of any programs that involve our youth?
I think that's a good idea. And Jamoki and Cam, if you all are still on the call, I think there were mock trials and tribunals back years ago around reparations. I know ANRO did some, and other groups may have done some. I can't remember if we did any in Cobra, but that's an excellent idea. One, just for its educational value, getting people across ages, really, but I think you're right, for younger people to really get engaged with it and learn and make the argument. And in the trial, it could be mock trials, it could be other kinds of debate forums. I think that's an excellent suggestion. One of the things, just briefly, we're working, our project is working with the Fulton County Reparations Task Force, and the chair of that task force is talking with us about what we're doing, helping them do research. But one of the things that we talked about, which I think Nick mentioned before, is that once you have a harms report, then you go to the remedy stage, right? And one of the things that we're talking about with her, just begun discussions, is she is talking about saying, here's the harms report, and then having a few months, maybe, or a couple of months before you get to the actual remedy stage. And one of the things that NCBL Georgia chapter, who is working directly with us on, we're talking about, that could be an absolute fabulous opportunity to spend time, as I think that was Curtis raising the question, or whoever raised the question about the mock trials, to have full discussions of what does reparations look like? This is the harms report. What would it look like to make repair? And we could do that in all kinds of ways. I like that idea of the mock trial too. Thank you.
Another proposed idea is, do we have a legislation wing whose sole purpose is to write bills and lobby the government? We need to research bills such as the Indian Appropriations Act to model our proposed laws after.
So that was one of the directives given to me by First Repair in terms of the legislative toolkit, was to try and have a template for legislation. And one of the things we discovered is that because of, we have 50 United States, and every state does different things differently, and each local jurisdiction within those states does things differently. It's kind of difficult to come up with a template. So what we did was we came up with sort of a framework all the way around on what should be included in whatever that bill looks like. And that's the 5 things that we went through in the slide presentation. But incorporating by reference the harm report, ensuring that you have acknowledgement and apology, banning the actions that led to the harm. All these things need to be included in whatever that legislation looks like. Florida, for example, when they passed Rosewood, Florida is unique, that we were able to find is unique in the sense of they have an idea called a claim bill. And what that is, the state has laws on the books, but they have statutes of limitation. And so let's say you're outside the box on the statute of limitation, you can petition then the legislature under the claim and to create a claim bill, which allows the legislature to go outside the statute of limitations and accept responsibility for actions of the state. It's one of the few states that we understand actually has a claim bill type of legislative option like that. And so that's how Rosewood, reparations for Rosewood was able to be passed. It was through that claim bill process. We haven't really found any other state that does that. So it's difficult then to try and say, like, you should write a bill that looks like this. We can just tell you the elements you should put in because each state is different.
Thank you. Nick, did you want to say something in mass about the importance of the admission by the wrongdoer?
Sure. That admission is sort of the linchpin. And I know that, again, I talked about earlier how some of those elements are present by the United States is already, like President Clinton issued the apology for slavery, right? Like we have some of those elements already there, but without an admission of or acknowledgement or accountability for the harm, any sort of program that is developed is likely to be thrown out by the Supreme Court, because now you don't have that compelling governmental interest in order to, which is like the first element of strict scrutiny. You don't have that compelling governmental interest that requires repair and restoration in the first place. And that's what my point was in terms of the Harvard affirmative action case. These universities have claimed that their affirmative action programs are an effort to increase diversity, but never at any point in time did they ever admit that they discriminated against Black students, Latino students, Asian students, or whatever in their admissions process to begin with. And I think had they done so, it would have been so much easier to implement an affirmative action program that would admit students of color at all these universities. And now we can't even use race as a factor in university admissions. I will say that it is very specific to university admissions. As far as I'm aware, employers are still allowed to take affirmative actions in the areas of hiring and promotions. But again, the Department of Labor's guidance on that requires that the employer spell out that they had discriminated against groups, whatever group that you're hiring, whatever group that you're promoting. You have to be able to show and prove that you discriminated against those groups before you implement a hiring program that actually benefits that specific group. You're allowed to do it, but you got to admit that you did it. And that's why I say that admission is such a key thing. Otherwise, it's likely to be thrown out by the courts.
One of the things I want to jump in here, and then I wondered, Theresa, we're watching our time because this is a great conversation, but we're running close to time. But is that our experts, we have several groupings of experts we've used to talk with our interns. Theresa mentioned their names that are working on some of this. They're drafting, along with Theresa and I, drafting sections of the handbook that all of you, once it's finalized and done and check marked, and we may even ask Nick to be a reader for us to make sure it's right, that you'll get. But one of the things that they said was Lisa Crooms, who is a professor at Howard Law School, was the acting dean until just recently. And we had Theresa Biner, who was a dean at University of Arkansas, Little Rock, Bowen School of Law, where I taught, who is now a professor. She teaches con law as well as Lisa. What they said, and to go along with what Nick said, is that if we're going to do reparative programs like in the communities, like Nick is talking about, you have to have a harms report that is specific to what was done, and the city has to be, if the city can't just say, oh yeah, we discriminated, there has to be specific data that shows what the acts of discrimination were. And so that's what's critical, and that's what Nick is saying many of the schools aren't willing to do. Harvard's not willing to say, yeah, from so-and-so and so-and-so, we only admitted one black student a year, something like that, because we discriminated.
A couple of last questions. I'm just going to stay on this theme. Any thoughts when the state or city has done ceremonial acknowledgements but come short of admissions, yet the harm is on the record and is on the record at the time of the ceremony?
So I was actually typing out a response to Joan, and she raises a very excellent point. And I can say that it's likely that these ceremonial acknowledgements are done in an effort to try and escape, um, you know, jurisdiction. Like they're afraid of litigation, right? So most, you know, as an attorney, and I know that Theresa and Adjoa are also lawyers, but I've spent most of my career defending on the defense side. So I can tell you that the advice that we would say is like, do whatever you want, but don't necessarily admit wrongdoing, because now you're exposing yourself to further litigation. But the reality of the situation and what we did in Evanston, most of these harms are well outside the statute of limitations, right? So if you're going to admit to this harm that was done 20, 30, 40, 50, 60, 70 years ago, most people would not be eligible to sue you because either they've passed along or they're outside the statute of limitations. And yes, the statute of limitations can be told for various different reasons. Namely, if the city hid its culpability and basically didn't, you know, the citizens had no idea, because really the standard is if you knew or should have known of this harm being done to you. But that's why it's still so important for the acknowledgement to happen. You know, a lot of it's done to try and make sure that no one else can sue or that they don't lose money. But the reality of the situation is that that number of people that's going to be able to sue you is so small that still would be within the statute of limitations. It would be so very difficult. And I think that's what the ceremonial acknowledgements are done. The reason why they're done is because they're trying to avoid that acknowledgement, that full blown culpability that they feel like would expose them to litigation.
Okay, she points out that to look at the ongoing harm.
Yeah. And so if it's ongoing, the statute of limitations, you know, obviously, again, it's I don't want to say it's told, it's doesn't exist because you're still having ongoing harm. And again, you know, that's why we advocate for legislative remedy, because when you have a legislative remedy, you can treat it somewhat like a class action. You actually have a class set of people that you're going to remedy this harm to. And any smart lawyer in that context will say, as a beneficiary or recipient of this restitution, you're not going to sue us for the ongoing harm. But part of the reparations is to stop the ongoing harm, right? So you can't just give acknowledgement and then continue to have racist and discriminatory practices and policies. You have to, you know, ban those practices and policies in order for it to really be effective.
So we have two last questions, and one of them I'm trying to work out, but the first one is, do you all think there are enough of us to convince the US government to pay reparations, or do you think we need to recruit outside of America for others who have the power to influence the US to do the right thing?
One of the things that I think, and Nick raised this earlier, but has been for a long time an international movement around reparations. I was part of the World Council Against Racism. There were many Blacks from, I think there was, I'm blanking on the group now, Cam wouldn't know, 400 people from, 400 Black folk from the United States went to the World Council Against Racism. Oh my God, I'm blocking on the name of it. There were many of us who participated in the preliminary meetings.
Urban 400.
Yeah, Durban 400. Thank you so much, Jamoki. The Durban 400 was organized by Conrad Worrell, Roger Wareham, and it's probably some others that I can't think of. Durban 400, those were grassroots representatives. There were others of us that participated in the hearings. I was co-chairwoman of the African Descendant Caucus. We had a co-chair from, I think it was Uruguay and one from Ghana. So to put pressure. So this is not, it's not working internationally is not new. There were things that happened after we came back that continued that international work. Uh, so it seems to me that one, as Nick pointed out, we have to recognize that we have a broad base of support for reparations, but we also have this focus here in the United States of reparations for Black people, descendants of Black people of African descent, for reparations for what happened here. I think we can't make it like them against us. It's part of the large movement, which I think was Nick's point, or part of Nick's point that he made earlier.
I'm sorry. Finish. Go ahead and finish, Adjoa.
So that's one. Two, my view, and it's not just my view, in Cobra's view, when Cobra was founded, there was a white group that was founded along with it to provide support for reparations. It was called CURE, Caucasians United for Reparations. And so it's no way just us, Black folk, are going to be able to be successful in obtaining reparations, whether it be federal government or, and I saw, I don't know if Nick is shaking his head in support of this, even at the local government. You have to have broad support. We have a section in our handbook that we are working on that's called buy-in. You've got to get people to buy in to the importance of and need for reparations, and people being across race, because otherwise it's too insular. It's too, we can be marginalized too quickly. And so we need voices for across that. So, and I feel, and I've been involved in the reparations movement, y'all know how long. It was before 87 when NCOBRA was formed, but not much earlier, 2 or 3 years before then. And this gray hair account, tells you that, I'm not a spring chicken. But I still know we can win. We just have to keep fighting, and it may not be. At one point, I thought it was in my lifetime. We've gotten some in our lifetime. Evanston is in our lifetime. Let's be clear. We've won some in our lifetime. So it hasn't been a meaningless, empty fight. We've seen results. And one of the things we've seen in NCOBRA and lifting it up is we've seen the movement grow from 1987 to being what we wanted to be back then. We said we wanted to be a household name. Well, it is in many places. Reparations is not a new word for people, not a new concept. So I'll get off my little.
I just wanted to co-sign part of what Adjoa said, is that one of the things that was left out of my bio is I am currently the president of the Cook County Bar Association here in Chicago, which is the oldest association of Black lawyers and judges in the country. And the sort of my message for this year is that we are stronger together. Mm-hmm. And understanding that there has been no legislative action of restoration or repair in the history of this country that did not include a coalition across race and nationality. It just doesn't exist in the history of this country. Black people only make 10 to 15% of the population. That 10 to 15% is typically concentrated in urban areas. So there's really no way we would be able to get a resolution or what we seek with just 10 to 15% of the population without allies across other races in the United States. And then broadly, the suggestion that was put in the chat that we also look at our allies internationally as well, because the harms weren't just committed against us here in the United States, and they're not continuing to be just committed against us in the United States. They're also be continuing to be against us in Venezuela, Brazil, Haiti, et cetera, et cetera, et cetera, all victims of imperialism. So we look at it here in terms of what happened in the United States, but imperialism is the same thing that's happening in the United States around the world.
And I think that's all the time that we have for questions. So Robin and Kara, I will turn it over to you.
I'll hop in. Thank you everyone so much for joining. Thank you, Theresa, Adjoa, and Nick for putting on this lovely presentation. It went really well, I think, and the visuals were really great also, just to help everyone see. And Robin, do you want to add some last minute words before we log off? Okay, I think Robin's busy right now, and also this is recorded, so we will be posting this on our YouTube, and that should be up in a few days. If you all have any questions, please email us or contact us at info@firstrepair.org. Thank you so much and have a great day.